Hi friends, and welcome to the 10th class of Indian Penal Code. Today as committed, we will discuss about the offences against property, which is chapter 17th of Indian Penal Code. So in this chapter we will cover theft, extortion, robbery, dacoity, dishonest misappropriation of property, criminal breach of trust, cheating, mischief and criminal trespass, which are the typically all the necessary elements of offences against property. So the first one which we are going to touch is theft. Theft is mentioned in section 378 of Indian Penal Code, and theft is defined in 378 as whosoever intending to take dishonestly any movable property out of possession of any person without the person's consent and moves that property in order to such taking is said to commit theft. I repeat, so what are the typical essential elements here? First thing is the intention. We'll repeat it with the component wise. Whosoever intending. The first thing is intending. There should be an intention. To take dishonestly. Second point is dishonest intention. Third is any movable property. It's applicable to the movable properties only. Fourth, out of possession. Possession of any person. This is the fourth point. Fifth is without the person's consent. Consent is a fifth point. And the last point is moves that property in order to such taking is said to commit theft. So this is the definition of theft. Now there is an explanation that thing attached to earth is not movable, but if it is unearthed or becomes capable of being subject of theft, then it becomes movable. Now there is a case which is Pyarelal Bhargava versus the state of Rajasthan, which is AIR 1963. In that it was held that such taking need not be permanent. Means if the person temporarily takes it, if there is a maid in a house and she sees a watch and she just takes that watch and puts it somewhere else in the house in order to taking it after some time, that can be covered under the theft. Section 379 talks about the punishment of theft, which is 3 years imprisonment or fine or both. While 380 says that if you commit a theft in a dwelling house where the people are living, the punishment increases to 7 years imprisonment and fine. Section 382 says that theft after preparation, which is made for causing death, hurt or restraint in order to commit theft, it provides a rigorous imprisonment of 10 years and fine. So here if the theft is with the deadly intentions, it can the imprisonment can go up to 10 years and that will be rigorous. Section 383 talks about extortion. So this was all about theft. Now let's see what is the difference between theft and extortion. Extortion is defined in 383 as putting a person in a fear of an injury to him or other and thereby dishonestly inducing that person to deliver a property, a valuable security or anything which is convertible to a valuable security. So the component of its definition is first, the fear of any injury. So you are giving a person a fear of injury. Second is to him or other. It need not be subjected to a person. It can be any relative of him, any friend of him, his son, daughter, anybody. So that is the second point. The third and the most important word in the definition is dishonestly inducing. You are inducing the person dishonestly to what? The fourth point, to deliver what? There are three things to deliver. The property, second is the valuable security, and third is anything which can be convertible to the valuable security. So this is the difference between theft and extortion, that here there is a fear of injury and then dishonestly inducing the person to deliver by himself. So that is the difference. So section 384 defines the punishment for extortion. It is 3 years imprisonment or fine or both. While 386 says that extortion by putting a person in fear of a death or grievous hurt will give a 10 years imprisonment and fine. So the third offense in offense against property is robbery and the fourth is dacoity. So we'll see what is robbery first and then we will relate dacoity with robbery. Robbery is defined in section 390, which says in all robbery there is either theft or extortion. So then it further defines that when a theft is a robbery and when there is extortion is a robbery. The first condition when a theft will be considered a robbery is if in order to commit the theft or attempting to do the theft, the offender causes or attempt to cause death, hurt, wrongful restraint or fear of instant death or instant hurt. So in order to commit the theft or making an attempt to commit the theft, if a person uses or attempt to cause death, hurt, wrongful restraint, or fear of instant death or instant hurt, he is supposed to be covered under the robbery. Now, when the extortion is robbery, if the offender, while committing the extortion, he puts the person in fear or instant death, instant hurt, or instant wrongful restraint, he is supposed to commit the robbery. So you can typically see that theft supplemented with the causing or attempting to cause death, hurt, or wrongful restraint, or fear of instant death or instant hurt becomes robbery, while the extortion, when it is supplemented with the fear of instant death, instant hurt, or instant wrongful restraint, it becomes a robbery. There is a case which is State of Maharashtra versus Joseph Mingle Kohli, where this all was held. Then punishment for robbery is rigorous imprisonment of 10 years and fine, but if the robbery is committed on highway between sunset to sunrise, then this punishment increases to 14 years rigorous imprisonment and fine. While attempt to robbery, which is mentioned in section 393, the punishment is 7 years rigorous imprisonment and fine. Now dacoity. Dacoity is mentioned in section 391, and which says when robbery or any attempt to robbery is committed by more than 5 persons, it becomes dacoity. And it was held in the case of State of Maharashtra versus Joseph Mingle Kohli in 1997. Section 395 says about the punishment of dacoity, which is life imprisonment or rigorous imprisonment of 10 years and fine. Section 396 says that dacoity with murder, if any one of 5 or more persons which are conjointly committing the dacoity, if they commit murder, every one of them shall be subject to the punishment of death, life imprisonment, or rigorous imprisonment for 10 years and fine. And this was held in the case of Rafiq Ahmed versus State of Uttar Pradesh, AIR 2011. So you have seen that robbery is related with theft and extortion. It is basically their extension, while the dacoity is the extension of robbery with if it is committed by more than 5 persons. Now the other category of offences against property is dishonest misappropriation of property, which is mentioned in section 403 and 404. In section 403, the punishment for dishonest misappropriation of property, which is basically the conversion to your own property, is mentioned, which is imprisonment of 2 years or fine or both. While section 404 says that the dishonest misappropriation of property which is possessed by a deceased person, if you do so with that property, the fine becomes 3 years imprisonment and fine. And if any clerk is involved, which was employed by the deceased, and he does so because he is entrusted by the deceased, so he will be having a punishment of 7 years imprisonment and fine in such case. Section 405 is a criminal breach of trust, which is another class of offense of property, and it is an extension of dishonest misappropriation of property, because it says whomsoever is entrusted with the property or dominion over the property, and even after that he dishonestly misappropriates that property or converts to his own use the property, or dishonestly uses or disposes of that property in violation of any direction of law, then he is supposed to be committed the criminal breach of trust. So criminal breach of trust has 3 components, 3 important points. One is the person is entrusted with the property or having dominion over the property. The second point is the dishonest misappropriation from such person or converting it to his own use, the property. And the third one is if he disposes of that property in violation with any direction of law. So in all these cases, conjointly he will be said to have a criminal breach of trust done. So the punishment for this is mentioned in section 406, which is 3 years imprisonment and fine or both. And if the same offense is done through a carrier or by a clerk or a servant, then the punishment increases to 7 years imprisonment plus fine. And these 2 conditions are mentioned in section 407 and section 408 of IPC. Now the next offense is cheating, which is mentioned in section 415 of IPC. It requires 3 components. When the cheating is occurred, it means there must be 3 things. First thing is the deceiving of a person. Second is fraudulently or dishonestly inducing the person so deceived to deliver his property. And here the case of R.K. Dalmia versus Delhi Administration, AIR 1962 comes in the picture. The third is the intentionally inducing that person to do or omit to do anything which he would not be doing or omitting as per the law. So the cheating has three components. Any of three will be said to have committed the cheating. The first one is deceiving a person. Second is fraudulently or dishonestly inducing that person to deliver any property. And the third one is intentionally inducing that person to do or omit any act which he is not supposed to do as per the law. So all these three conditions, if you force somebody to do so, you are supposed to be having incurred the cheating. Now there is another extension of cheating which is mentioned in section 416, which is cheating by personation. It means if you commit cheating by pretending or representing any person who may be real or imaginary, then it is supposed to be the part of cheating. The punishment for cheating is mentioned in section 417, which is 1 year imprisonment or fine or both, while the punishment for cheating by personation is mentioned in section 419, which is 3 years imprisonment or fine or both. So this is all about cheating. Now next is mischief. Mischief is a very important point in consideration with the exam, because sometimes very small question comes from only mischief. So mischief is mentioned in section 425 of IPC, and as per that it is said mischief happens when there are certain conditions. The first condition is intent to cause or knowing that it is likely to cause wrongful loss or damage to a public or to any person. So it first point relates it with the intention to cause the damage to the public property or the person. Second is causing destruction to any property or any such change to any property which is belonging to public. The third is such change must destroy or diminish the value or utility of such property or may affect it injuriously. So in all the three cases, there is the offense will be mischief. The punishment for mischief is determined in section 426, which is 3 months imprisonment or fine or both. But if the mischief is made to any public road, bridge or river or any channel, then the imprisonment may go up to 5 years, and that is mentioned in section 431. Now the last offense against property is criminal trespass, which is section 441 onwards. This is also a very important topic. So in criminal trespass, section 441 says the criminal trespass occurs when first the entry into or upon a property in possession of another person. You enter into a property of a person which belongs to other. Second, if such entry is lawful, then unlawfully remaining upon such property. So the first point says that unlawful entry, while the second says that you entered lawfully but you stayed unlawfully in that property without the consent of the owner. The third is such entry or unlawful remaining must be with intent of A. to commit an offense, B. to intimidate, insult or annoy any person in possession of the property. So understood. So there are three types of criminal trespass, three sections basically. First, you enter into a property of a person which is into possession of him but without the consent. The second situation is you are entering into the property with the consent, but you are remaining there, you are staying there unlawfully without the consent of the owner of the property. The third is that your entry or unlawful retention there, it is with an intent to first committing an offense, and the second to annoy, insult or intimidate the owner of the property. So there are certain case laws related to this criminal trespass. The first is State of Maharashtra versus Tamba Sadashiv Kumbi. This is All India Reporter 1964 case, where the accused is a VP of a school. He enters into a school, beats two kids and threatened the head of the school. So it is an unlawful entry. And the third condition, that he intimidated, insulted or annoyed the owner of the property. The second case is Sevani Transport Limited versus Kamaraju Bisoi 1991. In that case, the accused did not vacate company's flat taken on rent despite of the notices. So it falls under the second category, which is unlawful remaining. The entry was lawful, but the remaining was unlawful. Section 442 talks about the house trespass, which is a subclause of this section, which says what is a house trespass. House trespass is criminal trespass in any building, tent, or vessel which is used for a human dwelling. That's why it is called a house. Or any building which is used as a place of worship. In such places, if there is a criminal trespass, then it comes under the category of house trespass, which is section 442. Now, 447 says about the punishment of criminal trespass, which is 3 months imprisonment or 500 rupees fine or both, while 448 says about the punishment of house trespass, which is 1 year imprisonment or 1000 rupees fine or both. So, this is all about the categories of the offences against the property. Hope you have got a brief account of what is the syllabus of yours. So I hope this will give you a clear idea of the categories and the topics which you have to go through. I try to make a summary of all those topics. If you go to highlights, if you don't want to read long books, if you don't have time to do so, although in law you have to do so, but if you don't have time, you can go through my lectures first to get an account of what are the highlighting points you need to prepare for exams and interviews, and at the same time you should go through. And the most important thing is the creating a relationship between all the offenses, because the umbrella, these are part of the single umbrella, which is offenses against the property. So you should know what are the demarcation in among all these categories to have a better understanding on that. That is my hint to you. So in the next session, I'll be taking offenses in the marriage, and that will be the last topic of the IPC from my side. Thank you. Stay tuned.